you need to make them, what you need to disclose. On our panel, we have Scott Stamper from Atlas Insurance, Mark Mitchell from HMY, and Nick Zahair from Robert Allen Law. We're going to be talking about disclosures primarily in two contexts. One, in the insurance context, what you need to disclose to your underwriter, and then two, in the context of a yacht sale and purchase, what the owner needs to disclose both to his broker and to a potential purchaser, and what the broker needs to disclose to his customer. So we're going to start off by talking about insurance, because there are special rules that apply to disclosures in marine insurance. And the one I want to start with, actually, Scott, what can you tell us about ubere mai fide?
Ubere mai fide. So that's Latin, obviously, and what it means is utmost good faith. And the duty of utmost good faith involves ethics. And in fact, it actually is disclosure. That's what it is. It's a pre-contractual duty. Both the insured and the representative for the insurance, the broker that's placing the insurance with an underwriter, has duties and obligations to present and volunteer all material facts, circumstances, anything that would cause the underwriter to either be concerned or change the terms and conditions of insurance, whether or not it would be offered, whether to accept the risk, and if they're going to accept the risk, what deductibles might be applied to the risk, and what premium would be appropriate. So it really is disclosure. The ethics in ubere mai fide is not unique to marine insurance. It involves all insurance. And again, it is a contractual obligation that's owed by both the owner and the owner's representative insurance broker.
So, Scott, you used the word material. What does it mean that a fact is material, and what kinds of facts would an insurer consider to be material?
So the material facts may be the condition of the vessel. Often, in how we operate, we review marine surveys, etc. And the condition of the vessel, the experience of the operator of the vessel, the particular intended use of the vessel, how the vessel is going to be used. Will it be private pleasure strictly? Will it have some charter usage? Those types of things. And most material is probably the loss history, if any, of the insured.
And what are the consequences if someone applying for insurance either doesn't disclose something or misrepresents something? What happens?
So, failure to disclose material facts may result in the termination of the policy. It actually makes the insurance contract voidable from inception. And again, not to get Latin, but it's ab initio, as though it never existed. And there were material facts that should have been disclosed, but were not. And those material facts, the courts have held that an insured who conceals or misrepresents material fact has committed fraud, and it is a clear breach of disclosure. So it goes so far as to say that the grounds for policy rescission, even if the omission of the information is a result of the insured's mistake, accident, or forgetfulness, this non-disclosure is the cause, or gives underwriters the opportunity to cancel the insurance as though it never existed. Unfortunately, many times the discovery of the non-disclosure is only learned at the time and presentation of a claim. there's what happens in our business called the underwriters accept that what you've told them, as per the attorney's comments earlier, to be completely truthful and that they have received full disclosure. But at the presentation of a claim, there's an investigation. And oftentimes the non-disclosure is learned then. And so now we have an insured that's had some type of casualty, maybe bodily injury to a guest or something on board, and some material fact was either concealed or not provided, and this non-disclosure results in denial of the claim and in connection with cancellation of the insurance from its inception.
So there were a couple things in there I want to emphasize. One was if the policy is void ab initio, it's like it never existed. It doesn't matter if the misrepresentation or the non-disclosure is totally unrelated to what caused the loss. What caused the loss could be something completely different, but you could still not be covered because of a breach of that duty.
That is often the case, yes.
And then the other thing you mentioned is you don't have to be trying to hide something. It could be an innocent mistake, but if you're not careful enough about gathering those facts and making sure everything in the application is correct, you can still lose coverage because of that. What would you suggest someone do if they find out that through no fault of their own, something they put on an application is no longer true or wasn't true at the time they made the application? How do you correct that?
So if the risk has changed during the policy period and it would be material to the underwriter's decision as to whether if that set of facts were present when the policy was issued, that perhaps the underwriter would not have taken the risk, then the insured has a duty and an obligation to come forward with that information and present it to the broker. And in my office, my team, I'm like, listen, it's like the game of hot potato. You have information, we can't hold it. We have to disclose this to the underwriter. You go to them and let them know, we've just received information from our client. These are the circumstances. How would you like to handle this?
And in your experience, I mean, I'm sure it varies among underwriters, but generally, how do they respond to something like that?
So it runs the gamut from, okay, we're getting off this risk. We're done here. Or they can impose a deductible against the circumstances, increase the deductible. It really depends on the circumstances of how the risk has changed. If, for instance, somebody purchased their boat and says, I'm going to keep it in Jacksonville behind my house, and 6 months later they say, hey, I bought a house in Key West. I'm moving the boat to Key West. Obviously, that's a different risk parameter that the underwriters need to consider, and maybe the biggest risk parameter is the exposure to wind. And so in that case, perhaps the underwriter would be agreeable to taking and increasing the windstorm deductible from 2% to 10% of the insured value.
Well, I think the takeaway for insurance is that the standard for disclosure is very high. And that's both at the inception of the policy when you apply and then if things change. Because the consequences can be massive if there's, even if it's not your fault. I want to turn to disclosures in yacht transactions. And here we're talking about disclosing something like a past grounding or collision, fire, smoke, flooding, past insurance claims on the vessel, defects that were never corrected, things like that. Things that a surveyor might find, things that a surveyor might not necessarily find. Mark, I want to turn to you. How do you handle that when you have a new listing, say, and what kind of questions do you ask an owner? What kind of information do you want from them about the condition of the vessel and the history of the vessel?
So the broker's only as good as the information that he knows and the history he knows about the boat and what the owner gives him. And, you know, the sit down on a listing agreement is, you know, tell me about your ownership, any losses, any issues. Do you know prior owners? Do you know anything that's happened to the boat? And in most cases, you know, you probably get no. But at the end of the day, there's two different types of owners. I think most people would agree, the guy that would do anything to sell the boat, so it's going to be a no matter what, and the guy that probably gives you more information than is even pertinent to selling it. So you try to just decipher and, get through what's happened in the history and do the right thing. Sometimes it's worth not even listing the boat if it's got too much history. But doing your due diligence and trying to get to the bottom of it is key.
When you're dealing with the second kind of owner, the person who just overwhelms you with information about the boat, how do you decide what in that needs to be shared with a prospective buyer?
I mean, obviously losses, if there's an insurance claim that needs to be disclosed, big stuff, lightning strike. We were talking the other day with a couple of the guys. If there's a 1995 boat that had a grounding in 1997, and here we are in 2024, the grounding took place, they had to replace a shaft, they had damage to the boat, some fiberglass damage that happened that you know about. Does that have to be, are you liable to actually disclose that since it was so long ago? And I would turn to, management for the company or call one of you guys and say, what do you think about this?
And how would you react if an owner is reticent or doesn't want to share details about the history or the condition of the boat? Doesn't, for instance, in many listing agreements, for instance, in the ECSS listing agreement, there's a sort of check the box for history of the boat if there have been kind of these past incidents, and many owners don't even want to get involved in that. They don't want to make any kind of representation about the condition or history of the boat. How do you deal with that?
That's tough. I mean, they're obligated contractually to sign off on that there either has not been any material damage that they know about or there has been, and if there has been, then you got to dig into it. So I don't know really how to go about, and I haven't run across that problem. I'm sure the attorneys on the stage or in the room have, so they could probably answer the question a little bit better. But at the end of the day, if they check off that no material damage has taken place, then you got to trust that and go with it. And, after the fact, if something pops up, I've never had to deal with it. I know people have, but I think that the attorneys would be able to answer that one better than me.
If there's something that the owner is willing to disclose, an incident, say a lightning strike or a grounding, they have the information on it, how do you sort of present that to a prospective buyer in a way that they can use the information? But in my experience, a lot of buyers, particularly first-time buyers, they hear about something in the boat that may seem relatively minor, and it turns into a big thing, and they ask for every piece of paper that's ever been generated relating to this incident. How do you sort of manage a buyer in that situation?
That's pretty normal, I would think. If something like that comes about, of course, there's going to be a lot of questions that are asked, and that's the right thing to do. And I guess it depends on, are you the listing broker, are you the selling broker, or do you have both sides? Because there's a bunch of different roles there. For an example, for me, if you know about something, obviously it needs to be put on the table. You don't want to have something come back to you, your company, to the seller, if you represent the seller, and the buyer, obviously. But, at the end of the day, to put everything on the table so that someone can make a prudent decision is the best thing possible, and then try to guide them in the right direction and say, hey, listen, this is Florida. There's lightning strikes. It happens. It's not uncommon for, different boats that we're surveying or selling to have some kind of lightning strike in the past 5, 10, 15 years, whatever it may be. But my suggestion would be the boat's, it's the right one for you. It's got everything you want. Let's not only do a hull and an engine survey, let's do an electrical survey, get someone's blessing that goes through all the electrical systems, make sure everything's good with the boat. And still something may happen down the road, but at least you've done your due diligence and guided your client in the right direction.
I think one of the advantages of disclosing something up front before the survey happens is if there is a particular item that you think requires special attention or that the buyer wants to be satisfied on, and you hire, say, a specialist, or even you just tell the surveyor, hey, pay attention to this, versus you don't disclose something and then it turns up on the survey, and now they want to go back and look again. And a lot of times disclosing stuff up front can sort of focus the survey on certain things and calm the buyer down. Absolutely.
And we're all into, you strive for client retention. You don't want to lose someone's trust by not saying something if they, know that you know about it or know that you would find out about it. best just to come up forward and say, here's what I know about the boat, here's what we should do, and hopefully everything goes right. And if it doesn't, then, you reject the boat and on to the next one.
So brokers have the experience to sort of guide clients through this process of disclosing and how it affects the deal, but what makes sense from a business point of view is not necessarily always the same as what the law requires. So Nick, I want to talk to you about legal duties relating to defects. First off, you and I talked about this before the panel, and I'm not sure it's entirely clear, but do you think an owner has a duty to disclose known defects to a prospective buyer?
I think the answer is yes, but defects. What is a defect? Is the defect that there's some stress cracks in the corner? That's a defect. Does he have to disclose that? No. What the owner has to disclose are any issues with the vessel that materially affects the value. It was brought up a fire on the boat, right? That's going to have to be disclosed. The boat caught on fire, but like Mark said, 20 years ago, the boat ran aground. I don't think you have to disclose that. If the boat was repaired and it's been running for the past 20 years with no issues, I don't think you have to go to the potential buyer and say, hey, look, 20 years ago, I hit bottom. With hitting bottom, it depends on the degree of damage. I mean, every boat bumps the bottom at some point. If it just scrapes by and you don't even bend an ear on one of the props, you don't have to disclose that. I mean, there's no damage to the boat. There's nothing. But if the boat hits the rocks and takes, a big chunk of fiberglass out and they had to repair it, that's something that's got to come out. That's got to be told to a potential buyer. So
the owner in an arm's length deal, that's one thing. But the broker who's working with the prospective buyer, if he knows something about the boat, I think there's no question he has to disclose. Yeah. Whatever he knows, it could be material.
Absolutely. The broker needs to speak up. You can't sit there and be quiet and just hope the deal goes through and collect your check. You're going to get sued. You've got to speak up. You got to say, hey, look, the owner may have not told you, but I'm aware, this year this boat had a major incident on it. The boat caught fire. It sank. To the best of my knowledge, it's been repaired. But, have your surveyor take a look at that and make sure it's to your satisfaction.
So occasionally, not often, but sometimes we'll have a buyer who wants us to put specific representations and warranties in a contract that say the boat has never run aground, the boat has never been subject to a fire, something like that. How does that protect the buyer if you manage to get those into the purchase and sale agreement?
So if that is a representation and a warranty, and for non-lawyers, what does that mean? That means basically I swear to you there's nothing wrong, right? That's what it's saying. And it turns out that there is some sort of issue with the boat that they're hiding from you. It's fraud. You can unwind the entire contract. You're going to have to fight. There's going to be litigation. But you can unwind the contract to put the parties in the position they would have been in prior to signing the deal, prior to any money. The buyer would get all their money back, and the seller would get the boat back.
And if you're a seller, on the other hand, obviously you're going to resist making any kind of representation or warranty about the vessel, except maybe as to title. You're willing to stand behind title, but anything else you want to avoid. And in fact, the IYBA PSA has some very good protective language for the seller. It says, and the brokers actually, upon closing, buyer will have deemed to have accepted the vessel in its as-is condition. Seller and the brokers have given no warranty, either express or implied, and make no representation as to the condition of the vessel, its fitness for any particular purpose or merchantability, all of which are disclaimed. So there's a broad disclaimer of representations and warranties in the IYBA PSA, but you can't necessarily rely on that. That doesn't protect you if say, you actively conceal a defect on the vessel.
Right. So that is a clause in the contract. So contracts are only enforceable if both parties are acting in good faith, if both parties are on the same page with it. When these clauses no longer apply, if there's fraud. So in an instance where, let's say, the boat did catch on fire, which is, we're starting to see it. Everybody saw the fire at Lursen. Boats do catch on fire. It's more common now because there's more boats than there ever was. So the boat catches on fire, and the owner of the boat brings it to his friend's boatyard. They shovel it in the back. They clean it all up. They fix it, and they sell it, and they don't tell anybody. That's active concealment, right? They concealed the problem. If there's, a crack in the stringers, some of these older center consoles, the stringers crack. If the owner of the boat just lays a sheet of fiberglass over the stringer and paints it, that's active concealment. That's not telling the potential buyer, hey, look, the stringers are cracked. They concealed it. So those examples would constitute fraud, and the entire contract would be subject to be unwound.
It doesn't matter what's in the contract. It could be airtight, as is, no reps and warranties. Doesn't matter if you do something like that.
Yeah, it doesn't matter. What it is, it's called rescinding the agreement. And I know the IYBA purchase and sale agreement does have a clause for IYAC, the use of an arbitrator. In that situation, you may have to go to a judge. You may have to bring that contract to a court and have a judge make a ruling. Even though you agreed to arbitrate, in that situation, it's not completely clear in case law whether an arbitrator has the authority to rescind a contract due to fraud. You may have to go to a judge and either get the judge to issue a ruling giving that arbitrator such authority, or the judge may keep the case.
So what does the as-is clause, assuming the seller isn't doing anything fraudulent, how does an as-is clause protect the seller, an innocent seller, let's say?
So in the IYBA agreement, it as is means you're taking the boat as it is, and the buyer has an opportunity to come in with a surveyor. And so at an arm's length deal, that's what that's called. That's the legal term, but like a handshake deal, that's why it's called arm's length. The buyer has the opportunity to inspect the boat, and the seller does not have to disclose issues with the boat that could be found by the survey, as long as those issues are not, material to the value of the boat. So, stress cracks, a scratch, maybe the ice maker doesn't work, that type of stuff. That's not the material effective value. So that type of stuff would not have to be disclosed, and the surveyor, it is the job of the surveyor to find that stuff.
And then one last thing I want to touch on, something that happens sometimes is brokers and lawyers will attach the listing spec to the purchase and sale agreement, usually just to show what the vessel's inventory is. But if you have a description of the vessel in the listing spec that turns out to be false, something that's not correct, and that's made a part of the agreement, that's something the seller could be responsible for.
Yes, it can. Recently, I dealt with an issue with a buyer who put a deposit on a boat and discovered that the boat was partially wood. Thought it was fiberglass, discovered that the boat was partially wood, and the listing itself never mentioned wood. So as soon as he found it out, he rejected the boat. I want my money back. The listing then changed. They made a change to the listing saying that the hull is partial wood. If the deal went through and that listing was attached, I think the buyer would have a very good case to go back to the seller and say, hey, look, I was lied to. You don't see listings attached to smaller boat deals usually. It's mainly large yachts and stuff like that.
So I'd say, first of all, obviously you want to make sure that your listing spec is correct. But I think even if you're pretty sure it's correct, it's a good idea to include some kind of disclaimer that says it's not a rep and warranty. And then also, if you are attaching it to the agreement and it's only for purpose, let's say, the inventory, I would make that clear when you attach it, because otherwise anything in the listing spec could be held against the seller, which is obviously not what you want. So I think those are the questions I had, and I wanted to leave time for questions from the audience. If there are questions about disclosures, either in insurance or sales or in any other context.
So I've got one while I'm up here. Scott, this is for you, because a lot of times brokers assist the buyer in getting insurance, and they call you, hey, can you help us out? How do you deal with telling the buyer, hey, this is what's excluded in your coverage, right? Because most people, they're not reading the policy. So how do you present to the buyer, like, hey, look, the insurance company's not really helping you out on these issues, and how do you deal with the exclusions or and that stuff?
It's part of a conversation where we explain to them what they're covered for. This is what the policy is intended to do, but here are some things that might surprise you wouldn't be covered. and here's some things that you need to pay attention to. And gradual deterioration, lack of maintenance, those are pretty big loopholes for an insurance company to jump through if you've not maintained your boat well. And so we get into those conversations on the phone, and in some cases I will just snapshot the list of exclusions to the policy and say, pay attention to these. And in many cases, well, it used to be that we had more insurance companies to offer to people and say, look, this is more expensive, but it covers mechanical breakdown. This policy absolutely excludes mechanical breakdown. Well, it's a brand new boat. I've got 3 years of warranties. I'm not concerned about that. It's got cats, and I've got 3 years warranty. Maybe I'll buy the extended warranty. I'm not really concerned about that. I'd rather save the $4,000 on the insurance premium. Okay, well, that's what you're getting and what you're not getting. So we try to go through that with them.
It's helpful.
Yeah.
Hi, thank you, Judy Waldman, JW Yachts. I'm one of the old timers, and one of the things that I do when I get a listing is I ask the seller. I have a list. Has the boat ever been in any collisions, had significant groundings, taken on water, had a fire, had any issues that you want to disclose? And then my final question is, as a buyer, is there anything you would want to know if you were the buyer of this vessel? And that's where I come into a bit of a disagreement on a grounding that might have happened 20 years ago, is you don't want your new owner at a dock in Fort Lauderdale and a guy on the boat next to him says, oh yeah, I remember when that boat was in the yard and she came back here after she already had her damage fixed. You don't want, it's a small world, and those stories do linger. So I think that that's another important point, is to be able to say, 20 years ago, this boat did have a grounding, and they did have to rebuild or replace the shaft or whatever, but everything is repaired, and the fact that this boat has had, 5,000 hours on her engine, or she's crossed 2 oceans or whatever, is obvious proof that the damage was properly repaired and there's been no subsequent issues. But I do think it's important to disclose it, because when that owner finds out, he's going to be pissed about it.
So I want to follow up with that question, because I had managed, been managing lightning strike. Took a lot of damage, going to war, and there was a tug of war between I wanted to warranty guys who lightning strikes.
You're not talking loud enough.
So
Again, I'll abbreviate this. I've been managing a lightning strike, okay? And throughout this $1.5 million damage lightning strike, the owner came to me and said, when I go to resale, is this going to hurt me in the resale market? And I said, yes. And he said, but I fixed everything. And I said, I know, but that doesn't really matter. It's this perception or this inherent defect kind of thing. And I was talking to a colleague of mine yesterday, I won't say who it was, and I was talking about disclosure for lightning strikes. And then it came up, you brought it up, and then you brought it up, if something happened 20 years ago. And my colleague said, not a standard, but a rule of thumb might be, if that boat has been performing for 3 years, let's say 3 years after the strike, he said that should be pretty good demonstration. Do you still need to disclose, or what if it was 20 years ago they hit the lightning strike? The way lightning is, the gremlins are all over these things, 20 years later. So do you need to disclose on that basis, I guess is my question. The boat's been in service, electrical survey, 3 years, boomity boom. What is the standard, or I guess is what I'm saying? Is there a standard?
I think there's a difference between what you're legally required to disclose and what it makes sense to disclose. If the problem, in my mind, is if the buyer finds out about that from another source, you're out of luck. It's much better if you tell the buyer up front and you let them hire an electrical surveyor to check the boat out or something like that, even if you think it wouldn't meet any kind of legal standard for disclosure. And the other thing is, you mentioned with lightning, even if you're reasonably sure that the boat is sound, there's a certain stigma that attaches to that because people know problems can come back years later. There's a famous case in real estate about disclosures in real estate where these people had been marketing this house as a haunted house. In the neighborhood, it had a history of there was a murder there or something. It was a haunted house. They invited people to the house. And then when they went to sell it, they covered all that up. And the buyers found out about it and sued them and said, you sold us a haunted house. And they said, well, there's no such thing as haunted houses. We didn't have to disclose any of this. And the court said, hey, look, you marketed it publicly. You put it out there that there was something wrong with this house. You profited from that. And it's got a great line. The court said, as a matter of law, the house is haunted. And so they said they unwound the transaction. This was something you had to disclose. So even if there's nothing physically wrong, I think sometimes there can be a certain stigma that attaches because of these things. And it makes sense to disclose it even if you're confident there's nothing wrong with it.
Yeah, Bob, you said what's the rule, right? There is no hard and fast rule. Like 15 years, you don't have to say a word. It's going to be what's reasonable. And what is reasonable to us may not be reasonable to the buyer and is definitely not going to be reasonable to a judge, right? Judges don't boat. They don't have boats. They don't go on boats. They have no idea whether the boat struck by lightning 20 years ago is the same damage as a boat struck 2 years ago. So you're going to have to make a judgment call. And in this business, being honest and being open is probably the best decision, the best move, because you never want to be known as the yacht broker that hid something. Don't buy it from that guy or that girl. She won't tell you the full truth. And you don't want to have a dark cloud over this boat. You know, a boat gets into a bad accident, it's all over, these days, it's all over Instagram, Facebook, you know, qualified captain, instantly it's all up there. So the black cloud is instantly on the boat. And the information is so readily available that you're better off just coming out and saying, hey, you know, lightning, fire, stuff like that, some major issues with the boat, you're better off coming out and just saying something off the top.
So, Nick, you had mentioned that if it's a material disclosure, even with the as-is, where-is clause, it should be disclosed. So, let's say we've got an owner, it's got a 20-year-old boat, big boat. He contacts you and says, I want to sell it as-is, where-is, I'm busy. It's got a long history. I don't have time to give any information. I'm not going to sell it without a survey. They should survey it, and it's on them. Caveat emptor for the law school nerds. It comes out that there is something that the surveyor missed. It wasn't concealed. It's material. Doesn't rise to the level of a defect in title. Do you think there's an opening there using a standard ECSS agreement, as is, where is?
So I want to make sure I get your question right. There's a boat being sold. It's got problems, but the owner doesn't want to say anything. He's like, look, you figure it out as is, where is. And something is missed on the survey. More likely than not, the seller's going to walk free from that.
But he's still going to get sued.
He's going to get sued, but he's probably going to be successful. Going to get sued. The surveyor's going to get sued. Right? We're in the U.S. Everybody gets sued. It's actually terrible. It's what I do for a living, but it's terrible. You know, everybody's going to get sued. You know, as yacht brokers, it's important that you get the right surveyor involved. I'm not going to name the names of preferred surveyors, but there's while we have insurance up here, there's something called an errors and omissions policy, and the big time surveyors, they have those. They have the policy that, you know, people make mistakes, people mess up. And what that insurance policy does is say, hey, look, I made this mistake. Here's my insurance policy that covers my mistakes. Your smaller surveyors, they're not going to carry that. You know, they're not going to carry an E&O policy. And so what is the owner left with? The owner can sue the surveyor. They don't have money, right? They don't have, the surveyors aren't sitting on $1 million mansions on the intercoastal with boats. Right? They're just hardworking people. So you're not getting anything out of the surveyor. You can sue the seller. Maybe you get some sort of resolution prior to a trial or a final hearing. In that situation, I doubt it. I think the seller's going to say, no, this is as is. I didn't conceal anything. It changes when you have proof of concealment. And that's where I think the line gets drawn. If you have proof of concealment, they painted over something, they repaired something and covered it, they screwed a board over top of an issue and painted over it, like hopefully they don't see it, that's where you blow the contract up and you get your line to possibly be successful.
And in that situation, you have the seller, maybe a shell company with no assets. It's protected by disclaimers in the purchase and sale agreement. You've got the surveyor, who, is, as you said, probably doesn't have a ton of assets. And their contracts also have disclaimers against their mistakes that they might make. But then you have the broker, who he might have the $1 million house. And hey, guess what? He is a fiduciary, and he can't disclaim all these responsibilities. And so that's a very attractive target for a buyer who feels that he's been wronged. So that's why I think it's important for brokers in particular to understand that they're held to a high standard when it comes to disclosures.
Yep.
More questions?
Thank you.